So before we get into investigating all the evidence that the state has, we have to deal with your driver's license. That's always step one. So usually clients hire us right after they've been arrested and got out of jail a day or two later. And the very first thing we have to do is deal with the driver's license suspension that will be automatically triggered for anyone who is arrested for a DWI. So in Texas, you have a 2-week window after the date of your arrest to file a request for a hearing called an administrative license revocation hearing. We shorten it to an ALR. You have to request that ALR hearing within the first 2 weeks after your arrest. If you don't, then you waive any right you had to challenge the legitimacy of the automatic license suspension. If you don't request the hearing, then your license will be suspended around the 40th day after the date of your arrest. It can't be any sooner than 40 days, but it's not necessarily always on the 40th day. It's usually right around day 40 to day 45. You will receive notice in the mail that your license is officially suspended through the Department of Public Safety. So we always want to make sure that we file the request for the ALR hearing in a timely manner and we don't miss that window after your arrest. The ALR hearing itself, once it's requested, won't be scheduled anytime soon. It usually takes 6 to 10 weeks after the date that we requested it to officially get a hearing scheduled. Now, this hearing will not be in criminal court with a criminal judge. The license hearing, the ALR hearing, is through administrative court with an administrative judge, and they follow a whole different set of rules than the criminal setting would. Basically, all that needs to happen for your license to be suspended at an ALR hearing is for the officer who arrested you to show up and to either show the judge a positive breath specimen or blood specimen test that shows that you're over the 0.08 limit for alcohol in your system, or to otherwise explain to the judge what observations he made about your physical and mental capabilities at the time of the arrest that he believes indicated you were intoxicated. And again, this license hearing has a much lower standard of proof than the criminal court that we're going to be dealing with your actual DWI in. So for the most part, it's pretty easy for the prosecutor through the Department of Public Safety to get enough information out of that cop to convince the judge to suspend your license. They don't have to do a whole lot to meet their burden to suspend your license at an ALR hearing. But here's the important part. The cop has to show up to the hearing. If the cop doesn't show up to the hearing and they were properly subpoenaed by your defense attorney, which we always do, then the state is not allowed to introduce any of that evidence to prove you were intoxicated or to prove that you failed a breath or a blood specimen. The cop is the only one who can introduce that evidence to the judge. So if the cop doesn't show up to the hearing, we win automatically. And so does that happen all the time? No, but it happens often enough where the cop doesn't show up for whatever reasons that a good DWI attorney should always be requesting these ALR hearings just in the off chance that they get lucky and the cop doesn't show and they save their client a license suspension. Now, if the cop does show up to the hearing, it's still a very valuable opportunity for your defense attorney to get a chance to question, to cross-examine that cop about everything they did with relation to their investigation when they arrested you. And because this is such an early hearing as far as the relative time frame of a DWI case, oftentimes you can catch that officer unprepared. They haven't had time to be prepped by the criminal court prosecutor like they would by the time you get to trial on the DWI case. So oftentimes a good DWI attorney can take advantage of this cop not being prepared and can get them to answer questions that they otherwise might not answer in the same way later on at trial. And you can use that information that they testified to in the ALR hearing against the prosecutor later on in the DWI case. So again, filing the request for the ALR hearing within the time frame is crucial to any good DWI defense.